Hi, so this is the first class that the Committee of Internation is holding for this year's competition. So welcome to our first class. My name is Regine.
And my name is Devi, and we are going to be the one who's taught you things about Research 101, especially for this climb.
So the first class will mostly be about research. We'll discuss some basics on how you should do your research and where you should look. So hopefully that will give you some useful tips. Okay, so basically, mooting is about making persuasive arguments on behalf of states. Or
if you're concerned about the humanitarian stuff, usually we're talking about individuals that are going to be convicted of international crimes. But let's consider our moot problems in this year. Since we are going to talk for state versus another states, let's put that aside.
Okay, so we'd also like to emphasize the fact that you actually have to make arguments and not just be persuasive. So you actually have to do a lot of extensive research and critical thinking to be able to make good arguments within a moot. And, well, hopefully we'll teach you a little bit on how to do that. Okay, so moving on then to the issue about what you're really doing. Basically, because you have to argue on behalf of states who have opposite views from one another, you have to exploit vagueness and, a lot of holes. Not really holes. A lot of
just facts.
A lot of, just
interpretations.
A lot of interpretations, I guess. The law is... Well, international law does have a lot of sources like treaties, customary international law, and general principles. But there are still a lot of areas in the law that are still very vague, things that are still open to exploration, which is precisely what we're asking you to do with this year's problem. So even when there is a rule, and even when it's seemingly set in stone, there's always a way. There's always a way to argue a case. And you can do this, for example, when there is a clear case that goes against you. You can distinguish your present circumstances by distinguishing the context, finding contradictory authorities, arguing whether the rule of law is actually applicable, etc. So there's always a way, guys. We know that you're probably frustrated reading our moot problem, and we do know that we made it quite challenging for you guys. But just know that there is an answer for both sides, and the compromise is fair, so you will not have impossible claims.
Next. Okay. You have to formulate your arguments in order for you to make a convincing memorial submissions.
And pleadings.
And pleadings. There are several steps that you should be considered in a moot court competitions. First, in order for you to create a decent or good argument, first you have to identify the continuous issues within the compromise under international law. It might be a little bit tricky because sometimes you don't know what kind of law there's applied in there, so you might overlook certain facts and you don't think that facts is important. Well, it's actually very much important and essentials in order for you to make a solid argument based on that.
If you just make up facts or make ridiculous inferences, then the judges are clearly not going to buy your argument. You have to argue within the context of the compromise that we give you and the facts that we give you.
The moot problems that are given to you might have a certain strengths and weakness in several type of arguments. For example, that in applicant there are several strong arguments and also several weakness. In respondent, they might have a different strength point and also different weakness point. In this type of situations, you have to make sure that you exploit the right thing, that you do the right things.
Yes.
You have to strengthen your power and also,
your strong claims.
Yes, and you have to make sure to avoid as much conflict as possible when we are talking about the weakness point in your arguments.
And by avoiding, we don't mean that you just go, Your Excellencies, can I not discuss that issue? What we're saying is that you should find a way to be able to bypass that issue and to be able to answer questions satisfactorily as for why, for example, that weakness should not be viewed as a weakness, or maybe why that weakness does not apply in this case. There are a lot of ways to do that. Okay, so, and this is what we'd like to emphasize too. The only reason why Defi and I could make this compromise is because we've read extensively on the subjects of each respective fields of international law that we focus on. And it does take a lot of research, a lot of practice, a lot of dedication, and, just it's a long process for you to be able to gain the knowledge that you need to process things very quickly. So it will be, especially because we know that most of you are newbies, it will be frustrating sometimes because you do have to do a lot of research, but trust us when we say that it will be worth it in the end.
So don't be lazy and read.
So next. Okay, so in this class, we'll actually be teaching you how to research and formulate your arguments. We'll save writing memorials and formatting memorials for our second lesson, and pleadings for our third lesson, which is just before your competition, so wait for that, guys. It's like we're making a podcast.
Yeah.
It's okay, it's fun. Okay, so there are two important things for when you're researching that you must take into consideration, and that's first, where you look, and second, how you look. And basically, in the past, people would often have problems with researching because, they would have to go to a library, search through books, there's no Common App. But now you do have Google, and Google is your best friend. But like any friend, you do have to stay away from its bad side. You have to be very selective as to what sources you choose to include within your research, whether it be for your memorials or for your pleadings.
Source that you should never revert to. First, blogspots are not reliable sources. Neither are random theses from random university that you found on the internet that you usually found on the first search.
Right. So here's the thing about thesis. As much as we do respect, theses, undergraduate students, etc., international law and making arguments in international law does have a certain minimum threshold, which is that the person in question must be a highly qualified publicist. So, being an undergraduate would hardly qualify you as being highly qualified. So, yeah, we would not suggest you to look at people's theses. You can look at them. I mean, if you want to read in general terms about what the topic is about, then a thesis might provide you with some sources if you're that desperate. But we would suggest you to go look at journals, for example, which come from more reputable sources.
Second, you might also start by looking for some books that might help you, and we also concede that books are useful. But there are several books that you should never use as a source of your memorial and also pleadings, because there are minimum requirements for you to be able to use certain books. First, that books should be written by a highly qualified publicist. The good indication from a highly qualified publicist is that they come from reputable international journals. Things like our publications, such as usually
we do say books in general terms, as in both actual books, ebooks, and journal articles, which are usually compiled into books.
Several examples of highly qualified publicists are Oxford's.
What? Oxford's
books from Oxford.
I see. Yeah. Like for example, in IHL you have the Talent Manual that was published by Oxford. Like a lot of when you have like a book from publishers like Oxford and Cambridge, then you're pretty much guaranteed to have a good author. Also, journals are very important. We just kicked something. I didn't notice it. So journals, when they come from sources that are reputable, like for example, I might need to name drop like the Harvard Law Review, those important universities, then they would be very reliable. But of course, you should still read on the issue, find out who the author is, find out their reputation, etc. But rather than books and journals, we would actually suggest you to go look at publicists who have been cited in international judgments. So there are people like, the classics like Grotius, so there are a lot of people who are cited in international judgments. But and like one other important sources, the International Law Commission and customary IHL.
Yeah.
So those are both written by experts in their respective fields. We'll talk a bit about that in a bit. And Wikipedia is only okay if you use it for preliminary reading. Do not cite it in your memorial. We will be very angry if you do, because we're telling you now. If you do cite that in any work that you do in academia, you will be banned from academia forever. So please don't do that. Okay, so let's move on then to good sources. So, when you're trying to make an argument before an international court, of course, you have to look at what that court or a similar forum has decided in the past. So we would suggest you to look at International Court of Justice judgments, Permanent Court of International Justice judgments, which was the predecessor to the ICJ at the time of the League of Nations, as opposed to the United Nations now. You have United Nations arbitral reports. The Permanent Court of Arbitration has an entire set of case laws as well. And maybe Devi can talk a bit about this because that's her expertise.
And several another type of court for IHL used for if you're actually researching for humanitarian cases, that you will refer to cases from International Criminal Court, International Criminal Tribunal for Yugoslavia, and International Court Tribunal for Rwanda. These are sources that specifically talk about war crimes and also crimes about humanity.
Which might be useful for one of your claims, guys. Wink, wink. Anyway, when you deal with human rights also, you could look to the European Court of Human Rights, the Inter-American Court of Human Rights. There are a lot of regional courts and commissions which do decide on these issues. But you have to look at the relevance of these sources to your particular case. If you do have a human rights case, and you can look to those sources. If you have humanitarian law issues, you should look to other sources. Just adjust as you go along. So another good source, again, is the International Law Commission's reports, or their draft articles, or their commentaries. So they're a very reliable source for discerning matters of customary international law, especially, or general principles. There's also, of course, I think Defi can talk a bit about this, like IHL, customary IHL, and what? And
customary IHL, and also, what is it? Commentaries of IHLs.
Yeah. And lastly, there are also treaty commentaries by United Nations bodies. Those are often very important in human rights cases. We don't know whether that will be relevant to this year. You decide.
But here, there are differences of commentaries by UN bodies and also commentaries in IHL. You have to make sure that it's two very much different things.
Yeah, and you also, again, because we're talking very generally, we're not going to give you any spoilers for what you should do for your particular problem. So, you should be able to discern, okay, as much as I'm interested in human rights, but this particular issue, although it does brush on the issue, does not involve human rights as the main contentious issue. So you should learn to leave certain things alone and just not go too in depth into things that are not really relevant. Okay, so next we'll first discuss cases, and then we'll go a bit into the other things. Okay, so cases. Especially because this year's case is an interstate dispute. So that's a dispute between a state and another state. So you should prioritize interstate cases if you do have cases like this. And this is because courts are usually more drawn to consider those cases that happen between states, because the rules used are sure to be public international law, in the sense of it governing the relationship between one state and the other. And that's because, in certain aspects of international law, what is a similar matter being decided by the ICJ, for example, which decides disputes between states, might be different to that decided by the International Criminal Court. They are deciding different subject matters. They may have different evidentiary practices, for example. That's particularly important as well. So you should, if you do have an interstate dispute, prioritize interstate cases first.
If there are none, you can look for another alternatives that still involve a form of public international law like ICC, ICTY, and also ICTR cases. Because these are not necessarily an interstate dispute, because these courts are mainly focused on prosecuting a certain individuals. However, in the decisions of these particular courts, you should also talk about certain threshold that are also applied in international humanitarian law. Like what are going to be constitute as a definitions of, let's say, what is the parameter for you to be able to say that you kill a certain individuals, and also another criminal actions that are going to be considered, and also when an armed conflict starts and considered to be done. Usually the court decisions are considered all of these elements.
Okay. So you also have other cases which may be relevant in other fields of law. So you have, again, those regional human rights courts and commissions for human rights issues, or groups human rights issues. And you also have, for example, semi-public, no, they're more like private international law, but they do have certain decisions which may be relevant to you. For example, the International Center for the Settlement of Investment Disputes, or the ICSID. Yeah, you got that right. So that particular body does have disputes on investment and states' violations on investors' rights, which is not what we're discussing in this case, but they do discuss certain matters which are public international law, such as attribution or the Vienna Convention on the Law of Treaties. So if you are really desperate, you may be able to look there for sources. Okay, so next.
Try your best not to use any national court judgments, because though in IHL, you can use these national court judgments in pertaining for certain things, like for example on how state practice several military practice, and also standard operational procedure on several other things like how they're going to conduct an attack. And so it's important for us to see on how certain nations doing this. But however, in most cases, especially in the state versus state case, only use them if you are trying to explain the content of a customary international law or general principles that are applied.
Mm-hmm.
Because
even when you're trying to explain custom or general principles, you have to be careful not to cherry pick, as in, just using those legislations that so happen to favor you and discarding the other 100 states who say otherwise. If you definitely need to look more into what custom is and what principles are, and you need to, find out whether your research and whether your analysis of these national legislations actually prove either of those sources. So it's because, a lot of national legislations will be very distinct from one another. Some will happen to favor your case, others will not. When they are uniform, then maybe you can use them, but they're often very contradictory to one another. So be very careful. Okay, next.
About understanding the cases. Once you download the case and already find out several cases that might be important for your research, such as
the first batch material cases.
Sure. The moment that you're going to download those cases, you're going to see 100 of page of court decisions. First, you don't need to read the whole page because it's going to take so much time for you to understand all of that.
Whoa, wait. It might be necessary for some cases.
True.
It might be necessary. You don't have to understand and memorize everything, but you can skim those cases. But I'm talking from an ICJ perspective. I know that the International Criminal Court has far longer and more convoluted cases, so I do see where you're coming from. But as best as you can, do try to actually read, all of the parts of the case and understand them.
And also, the most important part when you see those cases are at least you understand the main outline for that case. The moment that you are trying to align some of your arguments with the case argument, you are also have to make sure that your conditions and your particular argument contain similar type of conditions and also several prerequisites that are used in that particular case in order for you to make a good argument. So you have to make sure that that particular case is relevant to your case and argument.
Yeah, you can't just go ahead and say, look, here's a case about genocide. We're going to apply it to a case of, I don't know. There are certain, and this is something that you also have to learn. There's a certain test of reasonableness to your arguments. So you cannot just say, this genocide case with these rules and, with this application, can apply to minor inconveniences like, I don't know, like a minor pollution. There are certain rules that may be useful, that are general in nature, but it doesn't mean that you can parallel every single thing within a case that's completely different to yours.
Yeah, you have
just because it's convenient,
You have to prove the relevance of that particular case to yours.
Yes.
And to simplify, how do you understand a rule in a case? First, you have to read. Okay, you don't have to read the whole thing at the full concentrations. You could
skim
and
find some spark notes.
True. You have to skim and find out which part of that case that are inherent with your arguments.
Mm-hmm.
If you're still confused, look for a journal or a book that cite that particular case, because people do that a lot.
Yeah, people often do analyze a lot of international judgments, and we would highly suggest you to do this, especially because you're new. Because, even though you may be very good at English, for example, which we are sure you are, you might just have a language barrier sometimes that, prevents you from understanding the full context of the case. Sometimes there might even be an issue with you guys being very new to this entire thing and therefore not being able to understand the entire context of international law in which that case is set. So, it is important for you to go and look for these sources. But again, make sure that they are highly qualified, okay?
And second, you have to break down what the rules is in a simple terms. You need to fully understand the rule that are applied in that particular case, and usually they explain why that rule is applied to that particular case. You have to ensure that at least similar flow of logic are applied to your case in order for you to be able to draw the same conclusions with that particular rules.
Right, and finally, you need to try to match the rule. Not necessarily the case, because you might find a rule in a completely different case from yours that is applicable for your particular circumstances. And you need to match the rule to the facts of your case. And again, this is why it's important for you to break down the rules in simple terms, because otherwise, for example, I'm probably, kind of betraying my old example here, but you might have a case about environmental damage where an international court lays down a general rule that may be applicable for cases of genocide, and this has indeed been the case. For example, just to give you a few examples. For example, a case about the expropriation of a corporation, which is the factory at Chorzów case, it has been used in a case concerning genocide by the International Court of Justice, simply because it was laying down a general rule of compensation. So again, you have to pay attention to the nature of the norm that's being laid down here. Is it really something general? Or again, are you applying, the standards used to adjudge genocide to a minor inconvenience that is not really applicable, right? So be careful to make that sort of distinction. Okay, next. So we'll be discussing other useful sources as well. In particular, we'll be focusing on ILC draft articles, IHL commentaries, and customary international humanitarian law. I have the honor of presenting the issue of the ILC's draft articles, and I leave the rest to Defi because she's the expert at that. So first, moving on to the International Law Commission's products. So the International Law Commission is actually a very important body. It was established by the United Nations General Assembly in 1947 based on Article 13.1a of the United Nations Charter. And its function is to initiate studies and make recommendations for the purposes of encouraging the progressive development of international law and its codification. So they're basically a bunch of really smart people. And what they do is they release several documents, actually. They release draft articles, which are codifications or proposals for what should be the content of a new international treaty, and some of its provisions contain rules of customary international law. For example, and one example that I can give to you because it's quite obvious, is the articles on the responsibility of states for internationally wrongful acts, or the RCWA. So, but even in documents which do contain customary international law, you have to be very careful because, again, going back to Article 13(1)(a), they do also make products that are encouraging the progressive development of international law. So there are certain parts which are not yet law, which are not customary international law, and which are more like suggestions for what the international regime should be on a particular subject. And be very careful with these particular rules. They are not law unless the articles are actually turned into a full-fledged treaty and your state is a party to that treaty, or unless that particular provision has since developed into actual customary international law as opposed to a progressive development. And the ILC also provides commentaries to the draft articles, which are very useful. So they basically they're a bit like the penjelasan tuan undang-undang. So they go really in depth into which rules are customary in nature. They explain a lot of judgments on a lot of issues, actually. So they go into the different international courts and tribunals, which judge a lot of different things in order to ascertain, with the existence of a customary international rule. So their analysis is very interesting, and it's very useful for you as well. And they also contain footnotes which tell you where to look for additional information. And but we do warn you: do not just copy and paste those footnotes. We will know. Okay, so I'll give the floor to Defi now.
Okay, second, we are going to talk about the customary of international humanitarian law. Okay, customary international law usually consists of rules that come from a general practice as accepted as law and is independent of treaty law. But customary of IHL is a crucial importance in today's armed conflict because it fills gaps left by a treaty law to strengthen the protections of overt victims. However, the customary of international law consists of two things. First, the customary of IHL that talks about rules, and second, the customary that talks about practices. It's usually differentiated because basically, just because it was practiced does not mean that it turns into a general rules that is going to be applied. So those two prerequisites has to be fulfilled in order for you to be able to draw a certain definition of what is customary of international humanitarian law. However, you are quite lucky because CIHL already being compiled into an integrated IHL database online. You can go look it up. These data are actually being codified by the ICRC, and it's actually going to be originally published by the Cambridge University Press. However, all it has been applied as a general international rule. So yeah, that's that. Several customary of international humanitarian law usually consist of fundamental rules that apply in IHL since war already conducted since before international law is a thing. Yeah.
People were greedy before international law came into existence. They're still greedy, but they were greedy even before.
Yes. That's why customary of international humanitarian law is usually very much general. In order for you to properly use CIHL, you need to know the details of circumstances that allow you to use that CIHL. Usually you could see it from the history of why that customary of humanitarian law exists, and second, upon how state usually practicing it. There are several principles on what are allowed in war and what are not allowed to simplify the CIHL. This kind of thing usually called the just war theory. Basically, it only has 10 theory, but
Professor Devi is not going to go into them.
No. And
you can go look them up yourself, kids.
And besides, CIHL is now, there are hundreds of it right now, not only 10.
Yeah, okay.
And second, international humanitarian law commentaries. These are different from your usual United Nations commentaries. Because law of armed conflict were made a long time ago. It was Geneva Convention were created in 1949, yeah, I'm sure. it's actually going to be it's done a long time ago, and now world already evolved, the technology changed, and people are usually a little bit more tricky as international law develop. There are change of threshold on when an armed conflict start. So there's that. That's why international humanitarian law commentaries is important, because it's ensure the Geneva Convention stay relevant still right now. Because see, a lot of commentaries exist from 1980 something till the latest one is coming from 2017.
Oh, the commentaries.
The commentaries are always updated. Because this thing has access, and commentaries is actually equally important as legal tools, as they provide more nuanced side and reference that are used by the court. Because since circumstances are changing, the threshold of how you approach a certain Geneva Convention rules is also changing. Though, spoiler alert, in international humanitarian law, they still basically use the main principle as the rule. However, on how you interpret that particular rules are very much dependent on the commentaries that you use.
And that, kids, is what you use to make your arguments.
Yeah, sure.
Okay, so of course, having discussed all of these sources, we would like to inform you that these are not exhaustive. So please do not be frustrated if you cannot find any of the sources that we've just mentioned. They do not contain all parts of international law, of course. Sometimes, especially when the issue is particularly vague or controversial, you do need to cite journals or books. That's fine, so long as, again, it comes from a reputable source. But we would suggest you to try to find the former sources, just because those are far more persuasive when you're writing memorials or doing your pleadings. So I think that's all on research from now.
That concludes it all.
Yay, it's over. So that's your first Moot class, kids. We hope that we've given you some useful tips. If you do have questions, we may be able to address them in the second class. So be sure to shoot us an email at Internation. Sorry, I forgot our email. Oh no.
I think it's stated in Instagram.
Okay, it's in Instagram, guys. So go look it up, do your due diligence, and contact us. Okay, that's it for now. Thank you. Good luck.